Okay, hello and welcome to this afternoon's seminar, COVID-19 Employment and What You Need to Know. My name is Cameron. I'm your host for today, and before I hand it over to the Godfrey's Law Employment team, I'll just run quickly through what it is we're going to do. So we have with us Brad and James, and they are going to run through a brief kind of state of what's going on. And then they are going to go to your questions and answers. Now, some of you have submitted some questions through email, which is great. Thank you so much for sending those through. You also have an ability through the chat function of Zoom to post some questions, and I'll be monitoring those, and during the question and answer portion of this segment, I will then pose those questions to our panel. So if you do have some questions, if what these guys are saying raises some questions for you, please pose them through the chat function to the host, which is me, and I'll put them to the team. So also at the end of this, we will do our best to make a recording of the session available. So if you feel like there was something you want to refer to later, or if you know of somebody else who you think would benefit from this, you'll be able to share it with them. So without further ado, I'll hand it over to the employment team at Godfrey's Law, Brad McDonald. Brad.
Thank you for joining us for this COVID-19 and employment law panel discussion. My name, for those of you who don't know,
Oh dear. I would say that we were originally going to be doing this from the Godfrey's Law office. And obviously, due to stepping up to level 3, what's happened is that we have all had to do this from our respective homes. So we're in 3 different locations, broadcasting into one. Lots of people are going onto the internet to try and update themselves, find information. So we do apologize for the quality, maybe coming in and out, and we will do our best at this time. So sorry you dropped out there, Brad. I'll hand it back to you.
Thank you, Cameron. Hopefully you can all hear me, and appreciate there are some finessing points with technology, and we're struggling with a bit of overload at the moment. So look, I'm on the Employment Law Committee for the Canterbury Western District Law Society, and have quite some involvement in education. In the West. So I think it's no understatement to say that we are into March 15. So sadly, we're no stranger to time. I'm doing these socially safe distancing level. The purpose of today's panel, and we've been planning this for a wee while, and the shape of it has morphed a little bit because we began planning prior to the enforced lockdown going to level 4, coming into other than have slate we were subsidies that are in place.
All right, Brad is having some internet issues. James, would you be able to introduce yourself and your role? And yeah, there's not much that we can do about the connectivity issues that we're having at this time, but James, if you'd be able to introduce yourself and your background.
Sure. Well, thank you for joining us today for this opportunity to try and help you and talk about some of the questions that are floating around in these fast-changing times. I've recently joined the Godfrey's team, and I have a background in employment law. I've also been keeping up with some of the latest information from Work and Income and from the Ministry of Social Development, as well as the Beehive release papers, because I understand that quite a lot of you have questions surrounding the wage subsidy. And
I can hear them. I can't see myself.
Andy, we're just live. If you could just pause there for a moment, please. So I'm looking here at the panel questions, and the first question that has come in says that I really want to know if, as an employer, we're expected to pay staff as if they would be normally at work. So this is a very difficult question to answer specifically, because every employment relationship is governed by an employment agreement, and they often have very unique and special conditions. But if we link that into the subsidy package which has been offered by the government, the underlying principle behind the subsidy is to keep employees in work. It is being provided to assist you in retaining employees to a minimum of 80% of the work that they were doing before the disruption. So if you are getting that subsidy, then you do have a duty to do your best and make your best endeavours, as the language of Parliament, to pass that subsidy on to those staff that are affected. Are you back with us now, are you, Brad? Can't hear from Brad there, so I'll keep going here. So the next question that comes along here, so how does the wage subsidy work? Is it paid as a non-taxable payment, or is it a reimbursement against the loss we incur? Furthermore, do I also need to get a signed agreement from each employee to agree to be paid at 80% of their normal week, with an agreement to allow each employee to top up to 100% if they either have sick or annual leave available? So that's quite a compound set of questions there. The first thing is regarding the tax nature of the payment. That's really accountancy advice, and something that as lawyers we don't tend to get into. What I can tell you though is that it's not entirely clear. There are opinions running either way as to whether it's a non-taxable payment or if it is a taxable payment, and unfortunately I haven't been able to get the straight answer on that reading the documents. Accountants will be very keen on whether it is a taxable or non-taxable payment, and that will hopefully become clearer in the future. As to an agreement with the employees in relation to topping up using their leave entitlements, it's entirely at the employer and employee's option to negotiate the use of any leave balances that are owing to the employee. So if you have an employee who would like to use some of their leave to top up that wage subsidy, and you're in a cash flow position where you can do that and you want to do that to help them, then there is no restriction. Where a restriction may come in is you cannot force the employee, and in general circumstances, and once again I just put a caveat out there that each employment relationship is unique, but generally speaking you couldn't thrust upon the employee the requirement to consume that leave. Indeed, if you are familiar, the government has released not only a wage subsidy, but also a leave subsidy, which concerns employees that may be in self-isolation and unable to work from home. And it is specifically stated in the information documents available that there's no requirement for any of those leave balances to be consumed first, the employees are entitled to receive that subsidy through their employers from day one, basically. Looks like the rest of the panelists have reappeared. We're all here, are we?
Yep, we're all here. Thanks for your understanding with the technical difficulties. This is all new territory for all of us. Thank you, James. Excellent. So look, I might just, James, thank you. You've cracked into things. That's fantastic, and started answering some questions there. So just in terms of my opening, obviously we're endeavouring to help you today by providing a view on the questions that you have sent through to the panel prior to the webinar today, which is fantastic. And we're trying to provide a helpful view. It doesn't necessarily replace considered legal advice, and I know that will sound like a standard lawyer's disclaimer, because it is. And the reason being is that there are a number of different overlays specific to each employer that may have relevance and bearing on the various questions that you're asking today. So you may well ask, well, what are those types of things, Brad? Well, one of those things is the terms of your own individual employment agreement that you have with your own staff, because you're going to need to reference that document, because it may well give some guidance and may well actually bind you into certain things. So if you haven't already, one of the best courses of action you can take is to dig out that agreement and make sure you understand the terms of the agreements you have in place at the moment. So in terms of the webinar today, we're really relying on the same information that you're relying on in terms of the information that's come through from government via MSD, via WINS, and via other channels. So in many respects, we're no further ahead from you as to the information that's available. Of course, the benefit that we have is our considerable employment law expertise and background. I see that Andy Ogilvie has joined us. Welcome, Andy. And I see that James has explained he's the newest member of our team. So between the three of us, we have over 30 years of employment law experience. All three of us also have the unique benefit of either having been or currently being business owners. So I think that's important to put across the table today, because we know what it takes to be in business, to stay in business, and the things that keep business owners up at night. And clearly this is the number one thing for business owners at the moment. So appreciate that there'll be many questions that you want answered. And at the moment, as you'll appreciate, this situation is constantly evolving. So information that was current even an hour or two ago may well be corrected in the next hour or two, or updated or changed, or further clarified. So we're trying to keep abreast of these developments as closely as we can, as I'm sure all of you are as business owners. And the purpose of today is to try and offer the help and guidance that you need right here, right now, but it can't represent specific legal advice. And in terms of today's webinar, before I hand back over to the panel to continue answering questions, and that's why you're all here, so I will shut up very shortly. I think there are some useful introductory concepts that I just want to outline for everyone today. So the first of those, the first realm, is the law that's at play in this area. Of course, the law that underpins all employment law in New Zealand is the Employment Relations Act of 2000. Colloquially referred to as the ERA, Employment Relations Act. So we'll be referencing the ERA, or the Employment Relations Act, today. We'll also probably be referencing the Holidays Act of 2003. The Holidays Act outlines an employer's obligations to staff around pay for certain different types of holiday, whether it be annual leave or sick leave or other types of leave such as bereavement and so on. Also, there's the Companies Act of 1993, which outlines the obligations that directors of limited liability companies have at large, and they must have regard to with respect to the running of your business. So there are the sort of three main pieces of legislation that are involved. Beyond that, there are some concepts that I think are useful to touch upon before we go further. The first concept I want to talk about relates to the Employment Relations Act, and it's Section 4 of that Act. And probably many of you as employers have heard of this section, and that section contains the duty of good faith. So employers have a duty to act in good faith towards their employees, and that requires employers to maintain ongoing and productive employment relationships. That is essentially, in my view, both the underpinning and goal of the Employment Relations Act, the continuation of successful and ongoing and productive employment relationships. So at the moment, we as employers and business owners are thinking about, obviously, our obligations to our staff. We're thinking about the potential liabilities we face and the potential dangers that are faced by our businesses as we move forward into these uncertain times. But I just want to reiterate that the law in terms of employment law in New Zealand is very clear that maintaining ongoing and constructive employment relationships is key. So we need to bear that in mind as an overlay when we're talking today about all these various things in play and concerns. One of the other things that may come into the frame of reference today, I'm sure, is the idea of redundancy. And some businesses may be thinking about, or may in future be forced to make staff redundant. In short and simply, a redundancy scenario was whereas an employee is deemed to be surplus to the requirements of a business. So that's at a very simplistic level, but it's important to understand the employee must be surplus to the requirements of a business. We'll also probably hear us talking about employment agreements, employment and IEAs. So an IEA is just simply an individual employment agreement, which most employees, non-union employees in New Zealand are on. And sometimes we may refer to employment contracts, so they can be used interchangeably. You also maybe hear some concepts such as force majeure. The force majeure clauses are included in some contracts, and again, that's why it pays to dig your employment agreements out if you haven't already done so, to see whether your contracts contain these types of clauses, because force majeure clauses, if they're in your contracts, may assist in this lockdown situation we're going into with COVID-19, and you may be able to rely on those to release you potentially from some of your obligations in the employment relationship by basically saying these are extraordinary, unprecedented times and the employment contract cannot be performed. Similarly, there is the doctrine of frustration, where an employer would potentially look to argue that the contract can no longer be performed because it has been frustrated due to unprecedented and extraordinary change of events, which means the business can no longer exist or be, can continue further ahead. So there are some concepts that you'll hear bandied about, and without unpacking those further, you need to be very careful and take specific legal advice before you look to invoke or rely on either of those concepts. Force majeure, you'd have to have it in your contract to start with before you could even use it. If it's not there, you can't. And frustration of contract is a contentious area of employment law. You also hear probably referenced MSD, that's short for Ministry of Social Development, and that's who's put out the wage subsidy and the wage leave payment packages that we'll be talking about today. So look, that's enough from me for now. I will hand back over to the panel and to get into your questions.
Just following on from there, Brad, I've just picked up off stuff that the Prime Minister has just announced some new packages, including bank relief loans and finance packages, particularly for SMEs, small to medium enterprises, and the banks should therefore be your first port of call when you start to think about what you're going to do about your business, because there's relief there. Just some of the figures that have come through, there's been 117,000 applications for wage subsidies. To date, 47,000 have been processed, so they're trying to turn them around as quickly as they can. So that's just a wee update on things that are changing. That was as at 3:20 today.
Okay, thank you, Andy. Great, that's a good update. So in terms of the questions, there's a question that's come through. If I get a payout from the government, can I just put that into my trading account, which is currently overdrawn, or do I need to keep it separate for the staff members to be paid as we go along? So, well, what are your views on that question?
I believe that it should be held in a separate account. It is effectively the same as GST or PAYE. It is trust money. It's given to the employer on trust to pay to the employees. That's my view.
Yeah,
If
look,
it goes into a black hole, there is always a risk that it may get usurped and used for other purposes, leaving the employees short.
yeah,
If I could
agreed.
chime in there, I've had a look through the definitions on the work and income site where the information about the subsidies is provided. And under the employer obligations heading, they talk about the subsidy being administered under a high trust model, and that they will be checking and verifying information relating to applications at a later date, and that may result in fraud investigations where anybody is dishonest in their application. So another rationale behind separating any money that you receive out is that if they want to audit the trail of that money, you won't be providing them with your all of your company transactional bank accounts. You will merely need to provide them, in my opinion, with the bank account that has been handling the distribution of those funds.
And the receipt of them, hopefully.
Yes. Yeah, look, I think it's really important, you know, for employers who receive this subsidy, and you know, if you haven't, I would encourage you to seriously look at applying for that. There has been, in my view, some different opinions flying around, but for example, you have to show an actual loss of 30% or greater for your business in terms of revenue as a result of COVID-19. It is actually actual or expected as the wording in the policy. So I would encourage employers who are yet to do so to look to make application for these subsidies if you think you're going to be in that category, because you're going to need to you know, undertake and seriously look at all steps you can take to keep obviously your business going and your staff employed, going back to the underpinning of the Employment Relations Act and that duty to you know, continue ongoing productive employment relationships. Now, I appreciate that that may not be possible for all businesses, but that's the starting point. In terms of there's a question here that may have been answered earlier, James, when I was having some technical difficulties. There's a question that about whether employers can just automatically pay employees 80% of their normal wage. So have you got a view on that in terms of how you would go about that if you're looking to drop an employee's you know, wage down to, say, the 80% mark?
I think that these circumstances are very unusual and they're crisis circumstances. So where a contract may require good faith discussions and negotiations and a procedure of written agreement to vary the terms of the employment contract, and in these circumstances, I think there would be some tolerance around that, especially if your cash flow situation and liquidity situation as a business owner is such that you actually cannot pay 100% of the wages to your employees. I also think that is impacted depending on the circumstances. If you have people that can work at home and are still able to fulfill their roles, then you do have a duty to pay them their wages without discount. However, if people are on limited tasks from home, or in fact they can't work at all because they might be a tradesperson or a painter, for instance, then that's a very different circumstance in which there would be a basis to reduce their entitlements.
I'm just going to chip in from time to time to pose some of the questions that have already been sent through to us from email. And one of them, if I was thinking about getting rid of someone anyway, is this a good time to make them redundant? And how do you do this if you've already received a wage subsidy for them? Panel.
Long story short, don't do it. Hello, we've dropped out.
Yeah, no, we can still hear you, Andy, so go ahead.
Right. the Employment Relations Authority and Employment Court would take a very dim view if, on inquiry, following a personal grievance being raised by the affected employee, the ulterior motive of disposing of that employee by redundancy was uncovered. It could lead to a very significant penalty being imposed on the employer. It could lead to orders for payment of lost wages, and could also end up with the employer having to have the unwanted employee foisted upon him or her by way of reinstatement. You have to be very careful going through a process, and any hint of predetermination or disciplinary undertones to it would be something that the authority and the court, in my view, would look very closely at, and the employer would be at some significant risk if that was able to be proved.
I'm in agreement with Andy in that all redundancy process should not be predetermined. There should be no decisions already made about who's on the chopping block, and using situations like this national emergency to dispose of people as a convenience. That is absolutely not the way to do things.
Yeah, and I would just loop back, thank you James and Andy, I'd loop back to the point, the underpinning of the Employment Relations Act to further ongoing and productive employment relationships, and that's why this wage subsidy and the wage leave payment package has been designed by the government, is so that businesses, to my understanding, don't en masse just shed staff. That's not to say, however, that businesses can't and shouldn't take a good hard look at the overall health and situation of the business as a whole, the needs of the business moving forward, and the potential difficulties that the business may get into with the overlay of some of the obligations that directors owe under the Companies Act of 1993 to act in good faith, and obviously to run solvent companies and not to continue to trade whilst insolvent. So in my view, that's going to require a careful analysis, whether you're a director of a company and a business owner, or whether you're a sole trader. These principles apply, I think, across the board to your overall position, and that's going to require some projection, into the future as to how this whole thing's going to look. And right here, right now, as a business owner, for myself and all of you out there, we've got a lot of uncertainties. We don't have crystal balls, but by the same token, we can and should be making financial projections as to how this is all going to look. Now, there will be some circumstances when we've done those projections and included the wage subsidies and all the leave payments, because they are two separate and distinct payments, into the mix, that we look at the numbers, we take appropriate professional advice from our lawyers and our accountants as part of a team approach, saying, well, gee, this just doesn't stack up. I might be able to limp along for another few weeks or months, maybe, depending on your individual position. But gee, by this time next week, I'm going to be in serious trouble, serious financial trouble. We may be trading insolvently, and these payments, even if they're available, may not alleviate the situation, and it may be so serious that we may need to look at taking other steps, to comply with our obligations under the Companies Act, or to shareholders and to other players. So, whilst today we're focusing on the integration of employment law with these subsidies that have been announced, there is a bigger picture here that will require business owners to take a real careful look at the overall circumstance in terms of all the different pieces that are in play. But you're going to have to factor these wage subsidies into your considerations.
That, just adding on from that, Brad, that any company director that does trade whilst insolvent could potentially face an action from a liquidator, making that director or those directors personally liable for all the debts of the company following a liquidation, if it was proved that it was reckless trading, which is another term for trading whilst insolvent. However, I would still go back to the point that I started my 2 cents worth in this webinar, that hey, your first stop needs to be your bank manager. There are packages there now for relief for companies. There have been comforting noises ever since this was flagged that we were going to go into this major crisis, that the banks were going to have to be told or have to take a fairly generous view as to loosening up credit and not coming down too hard on companies. So first stop, before you even get to the point of determining whether a redundancy is necessary, I would suggest is conversation with your financial advisors and more particularly your bank manager to see if your bank can come to the party. Let's hope that they're not just fair weather friends.
Just adding on to Andy's last statement there, I think anybody who's in a position where they are needing to consider redundancies, they have a duty to explore these wage and leave subsidies in the first instance. That would be a proper discharge of your duty of good faith, and a failure to look properly at the ability to obtain those and how they might apply to your employees would be a breach of that duty.
We've had a very interesting question come through at a time when most of us are being told that we have to stay home. This one's come through. If a company is registered as an essential service, are the staff obligated to work? My daughter is pregnant, works reception for a Warren Fitness workshop. She's been told she has to keep working throughout the 4-week lockdown period. Other than her having to take holidays for this, are there any other options? I guess I would also add that to say that if there was somebody who was concerned for their own health and safety and would prefer to stay home rather than work, what are their options there?
Yeah, thanks, Cameron. The starting point for me is obviously, again, the duty of good faith. And part of the duty of good faith is for parties to be responsive and communicative with one another. So for that employee in that circumstance, if she has any particular concerns over that mandate from the employer and concerns vis-a-vis her own health and safety, then she needs to explore those with the employer by putting them on notice of what her position is, what her concerns are, what her thinking is and why. If there are particular health concerns as a result of the situation, then they would need to be spelled out to the employer with some sufficient particularity, in my view, to discharge that duty of good faith in terms of being responsive and communicative, because the employer needs to have a good understanding of what the concerns are. I also think that the employee would be within their rights to pose the question of the employer as to what steps, if any, they can take to mitigate their health and safety concerns, and how they can make the workplace a healthy and safe workplace insofar as reasonably practicable in terms of the obligations under the Health and Safety at Work Act. That obligation goes both ways on both parties, on both employers and employees. So there's a dialogue that needs to be had there, and that dialogue, in my view, needs to be informed by some considerations and advice as to what the concerns are on both sides of the fence and how they can, if at all, be mitigated in a reasonably practical manner.
I think if the employee in that particular circumstance, being pregnant, could go to the doctor or get a doctor's certificate requiring her to self-isolate, there would be the access to the leave subsidy for the employer. It doesn't alleviate the problem that the employer has, that he's down one worker and is not likely to be able to replace that person. So, one view of the issue is the instruction from the employer lawful and reasonable. I believe it is lawful to require somebody to work when work is offered, and that's part of what the agreement. Don't forget, we've got an employment agreement. It's an agreement between two parties one to provide work and one to perform work. Two heads to the argument. So it's not a pick and choose. There's work available. You should make yourself available, and if you are able to work, you can work. If you're not able to work, there has to be a good reason why, and that would be a medical reason. Even though underlying that, of course, is the natural human concern of this fear of this great unknown of the coronavirus, particularly for an unborn child, that it could be a classic case of leave being covered by the subsidies available through the Crown. But again, that still leaves the problem as with the employer as to what to do about the vacancy that would be left by somebody on extended leave for 2 weeks, 4 weeks, whatever it is.
Just thanks, Andy. That's some really good suggestions there. Just thinking outside the square, I think the position mentioned was reception. Now, obviously, reception is is a high contact, face-to-face zone for an essential service. So, look, I also think that employers, as part of this duty of good faith, we're all having to work in a different manner, and I appreciate that essential services are essential and they must go on. But I wonder, for example, whether an employer could consider someone in that role, depending again on the medical advice and what that advice is, if it's been obtained that says, well, potentially there's a real risk to this employee's health and safety and that potentially the unborn child, whether it can investigate alternative working arrangements. That may or may not be feasible, but again, I think it's part of that ongoing discussion and consultation.
I'll just pop in here. I know that a lot of people have been asking the question, what is an essential service? And that has been an elusive term. If you read the different articles and listen to the news, nobody really knows. But the government has put up a website, which is covid19.govt.nz. And I see there that there is if you look at the current COVID-19 alert level, as you scroll down the page, there is an extremely comprehensive list of what are essential businesses. And just by way of observation, talking about the mechanics workshop, it does say that any entity providing services to keep vehicles operational for essential work purposes, example, vehicle testing, mechanics and tyre services. So I don't think that, and this is just my opinion, but I don't think that is a broad, every mechanical workshop can be open. I think there would need to be a corollary there that workshop is actually providing service to essential vehicles, which might be trucks for freight or ambulances, police cars, and the such. But that's just by way of comment.
Thank you, James. Cameron, I wonder if you could give us some more questions, please, because I think
we've got a longer 4-part version that I submitted to you earlier, but I'm wondering whether I read through one at a time or whether I read all 4 out and we kind of dissect it from there. So the first part, I have restaurants which employs 50 people plus. Do we have to pay staff while we are shut down for the 4 weeks, as I can't get the chefs and wait staff to work from home? I don't have a force majeure in my contract. Can I do anything else to argue frustration of contract? The second part of that, we have 95% of our staff on full-time work visas from other countries that work for us. Can we still give out redundancy? And how can we pay them for the 4 weeks notice, as in my agreement for redundancy, if we may not be able to, as we don't have income? Part 3, can we tell the other staff to take holiday pay this week until we can get them onto wage subsidy scheme? If it's in the 14 days notice to tell them to take holidays, can we tell them to take all their holidays and days in lieu as well? And then finally, can we still do the wage subsidy scheme for all our staff and then give redundancy after the 12 weeks, as we've got no idea what staffing levels will be needed? I imagine there'll be a few hospitality venues that will be in a similar boat, but I can go back to part 1. We'll address part 1 and go through it from there. So part 1, I've got restaurants which employs 50 people plus. Do we have to pay staff while we're shut down for the 4 weeks, as I can't get them to work from home? I don't have a force majeure in my contract. Can I do anything else, like argue frustration of contract?
On its face, I would say that yes, the restaurant is required to pay its staff. That's, again, harking back to the agreement. We have an agreement. The worker is ready, willing and able to perform work. The worker's place of work is no longer available, and the employer therefore can't offer work, but that is no fault of the employees. So the onus is on the employer to continue to pay, even pending receipt of the subsidy.
I think that's precisely why the government has come up with these subsidy packages, is to deal with these circumstances where the employment agreement doesn't have adequate provision. I also think that in a situation where those subsidies are being passed on, and sorry, I'm just jumping to one other part of that question concerning the redundancy at the end, I think that a responsible employer acting in good faith would be reviewing the situation progressively throughout the 12-week subsidy period, just to see how the environment looks. Will they still have a business? Has the time frame for isolation at home been extended? There are so many variables that we can't look into crystal balls and know the answer to that. We have to analyse it as we're moving along. And the decision about redundancies is not one for now, it's one for closer to the end, when you can actually make a more reasonable assessment of the circumstances and the condition of your business.
All right, the second part of that was we've got 95% of our staff on full-time work visas from other countries. Can we still give out the redundancy? How can we pay them the 4 weeks notice if they've got no income coming through?
Yeah, look, I'll just jump in there and just say, you know, obviously if these subsidies, to my understanding, apply to all employees in New Zealand who are legally working in New Zealand. So it sounds like this is as good as a situation where all the staff have work visas, therefore they are eligible, on my understanding, for this subsidy payment. And one of the questions that I don't think there's an answer to at the moment, but the panellists may want to express a view on this, is that this wage subsidy potentially, arguably, may be able to be used for notice payments under a redundancy compensation clause if an employer moves to make staff redundant after they have reviewed all their other options. That is an unknown as yet, and I'd open that to James and Andy for any comment.
Well, I'll just pop in just on the question of legally working in New Zealand. I have the precise definition from MSD about what legally working in New Zealand does mean, and it covers a New Zealand or Australian citizen. It covers somebody with a New Zealand residence class visa, or somebody currently holding a New Zealand work visa, or a condition of their New Zealand temporary visa that allows them to work in New Zealand. So, as Brad had alluded to, it's a general understanding of legally working in New Zealand, and therefore it's a very broad coverage. And so those workers on work visas are certainly covered by the scheme following that definition.
Andy, I think
this third part alludes to something you said, Andy, about the sheer volume of applications that are being put through. I know that the government will be processing them as fast as they can, but there's a lot to get through. So the part 3 of this question was, can we tell the other staff to take holiday paid this week until we can get them onto the wage subsidy scheme? And if it's the 14 days notice to give to tell them to take holidays, can we tell them to take all their holidays and their days in lieu as well?
again, without wanting to sound like a lawyer's answer, that's going to be somewhat dependent on the terms of your employment agreement. If your agreement has a forced shutdown period, like close down over Christmas clause in there, you may very well be able to rely on that and invoke that, giving, of course, the appropriate notice required by your agreement. Without that, it would need to be a subject of discussion and negotiation with your staff. It would have to be agreed by each individual staff member, and best practice would say the agreement of that staff member obtained in writing and a variation to the contract recorded in that way. I think in the absence of any other clause in your employment agreement, you would be in very dangerous ground directing them to take leave.
Yeah, and look, I'd just, thank you, Andy, jump in there and say two things. One is the standard, which has been alluded to in the question, the standard requirement under the Holidays Act, we require an employee to take leave is on 14 days written notice of that fact. Outside of any negotiation or consultation recorded outside of that in extraordinary times. And employees can, of course, request an employer to cash out up to a week's annual leave. Whether or not they would assist an employer in this situation is a different story, because obviously one of the concerns for all employers will be their leave liability balances to their employees and how they can either look to meet those at this point in time if there is some agreement to leave and they have some provision in the contract that allows them to do that, or otherwise in terms of consultation and agreement and variation, and how that liability may look as time goes on down the track, say in 12 weeks time, when at this point in time those subsidy or that subsidy period ends, what that liability balance might look like in another 3 months time. So there are some options available to employers, but there are some very clear requirements that must be followed under the provisions of the Holidays Act, and you certainly cannot force an employee with a unilateral decision or simply put them on holiday leave as of right. You'll get in big trouble for doing that.
Okay, and the final part there was, can we still do the wage subsidy scheme for all our staff and then give redundancy after the 12 weeks, as we have no idea what staffing levels will be needed?
I think we've probably already answered that earlier in this webinar, that it's a feast that needs to be tackled all the way through the whole process. You need to be reviewing and taking appropriate advice and considering all options.
Okay, we've just had one come through, and this says, for higher income employees, does the employer need to pay the employee 80% of their pre-COVID salary, even when the wage subsidy would not cover a quarter of that, particularly as this may adversely affect cash flow with no money coming in? And can we just amend the employment agreement and give them whatever we receive for them in the wage subsidy?
First of all, I think there's a few questions there. Amending the employment agreement absolutely would require the agreement of the employee. There can be no unilateral adjustment there. Second of all, the 80% requirement, it's expressed and requiring employers to make best efforts and best endeavours to pay a minimum of 80%. And I think that that's been done purposefully by Parliament, because every fact situation will be unique, and the facts that affect your cash flow or the amount of money the person's receiving, the work they may be able to do from home versus the work they may not be able to do from home, they're all unique factors to each unique situation. So it's impossible, I think, for Parliament to make it a mandatory requirement, which is why they haven't. But using your best endeavours and best efforts is something that you would need to be able to demonstrate if later on a grievance or a claim was brought against you as an employer by an employee that felt they had been disadvantaged through this process.
And I think, thank you, James. I'd pick up on that. Obviously, you know, even if you, for example, I mean, I reiterate the importance of consultation with your employees. If you proposing to pay them, say, less than 80% of their usual salary, and I would reiterate the fact that if you, even if you don't pay them that you know, obviously there'd be liability and accruing liability at some point in time for an employer to pick up the balance of that tab. And it may well be that there's some consultation and discussion with the employee around that. Of course, you have to bear in mind the very overarching principles of the Wages Protection Act in terms of what is and what isn't possible there. And there would be another factor that would need to be fed into those sorts of discussions. But merely, I would just like to point out merely that you reach agreement doesn't necessarily mean you may not have a bill down the line.
Okay, we've oh, sorry, Andy.
Some employees may be happy to negotiate a reduction in salary, recognising the greater public good, the greater interest, and in the interest of preserving their own employment too. So the first stop is discuss with your employee.
Yeah, and I think
probably after you've discussed with your bank manager.
Exactly, and I think, you know, for Cantabrians, many of us will remember back to earthquake days. We have been here before in some senses in terms of these wage subsidies. And I know, for example, with our own business at the time, we had those very discussions with employees so that we could continue to survive through the initial aftermath of that, when we had red zone areas and couldn't access workplaces and those sorts of things. In my experience of employees at the time was that most were very reasonable and willing to work with us for the greater good of the team and the business as a whole, and we're you know, quite open to you know, having those discussions around reductions in salary to get through the period and the aftermath. And I think you may well find that employees are open to those sorts of conversations at this point in time, because, you know, I think what the government is saying, in my view, with these subsidies is we're all in this together. We've got a long game. We don't quite know how long to all play. We're going to give you a significant, you know, boost to enable you to keep your players on board for as long as you possibly can and reasonably can, bearing in mind your other legal obligations that you've got to have in mind to, so that we can all get through this together. So I think all of these conversations are going to be part and parcel for employers moving forward, in terms of coming up with a strategy to see your business through and help it to survive, whilst you know, limiting the collateral fallout, and clearly employees and you know, your relationship with them is a key element of your business.
We've just got a couple of more questions that have been sent through, so we'll get to them. If you are watching and you've got a specific question that hasn't been answered yet, please send it through the Q&A function and I'll put it to the panel. And then once we've gotten through these last couple of questions, I'll throw it back to you for some final words and some summary on the situation. This one here is probably more relevant for hopefully at the end of 4 weeks, if the quarantine period has lasted for only 4 weeks. This one says here, when an employee phones up to say that they're unwell, how much information can I ask for before I cross a line? Some people phone up if they've got nothing more than a sniffle. So this is probably more when we're trying to get back to normal, but people may still be sick. How far can you go with the kinds of questions you can ask to determine whether or not they should come in or whether or not they're better off staying at home?
Yeah, thanks. So look, first port of call for me is always the individual employment agreement, the IEA, in terms of what that says, what you've agreed with your employees at the outset of your employment relationship in terms of the sorts of information you can request from them and the level of detail they are required to give you. even if that's not of health, we're talking about health, of help, you've got the good faith overlays under the Employment Relations Act, the duty to be responsive and communicative, and to act in good faith. So my view on that is that even if there's nothing particularly helpful in your employment agreement in terms of those obligations, an employee has a duty to be responsive and communicative and give you some further and better particulars as to what their health situation is, as to why they're unable to attend work. And of course, this is not forgetting the obligations of an employee who's absent from the workplace for 3 or more working days to provide a medical certificate at their cost. And that's not forgetting the ability of an employer to request an employee provide a medical certificate within that 3-day period, so 1 to 2 working days, 1 to 3 working days, at the employer's cost, of course, if they have serious concerns over the veracity or bona fides of an employee saying, hey, I'm sick. One of the problems you get there, and without going down the rabbit hole, is that many medical certificates are not particularly helpful. They don't provide a lot of detail above and beyond an employee is unfit to work. The Medical Council of New Zealand actually has published guidelines for what is actually required to be in a medical certificate. And it's my view an employer can request a certificate that complies with those guidelines from the Medical Council of New Zealand. They can be found online. So there are a variety of tools available for an employer if they need to go there, but the first protocol is the employment agreement. What does that say? What are the obligations under that? What did you agree to? Even if that's not helpful, then you need to outline to the employee what you are seeking. Now, there needs to be some careful questioning there, because an employee has a right, in my view, to not necessarily disclose their whole medical history to an employer. There are Privacy Act considerations is what I'm hinting at there. So an employee, though, needs to give an employer enough information for the employer to make an objective assessment of what they're telling them. So they're going to have to act in good faith and give them some detail. Gentlemen, do you have a view or anything to add on that?
Just wanted to touch on the sick pay aspect. I see a few questions that had rolled in where people were wondering about paying sick pay out. And sick pay is for sickness, and it's really only triggered when the employee is sick or is caring for somebody, a dependent who is sick, and the isolation issue of having to go into self-isolation is not a sickness. And so employees that are demanding sick pay in certain circumstances when they're simply self-isolating, in my view, would not qualify for that sick leave entitlement, which is not to say that the employer couldn't agree to make a sick leave payment.
Might be helpful too to go to the Privacy Commissioner's website, because they have put out specific advice relating to COVID-19, and one of the pieces of advice that was in there was that there are possible exemptions to the principles of the Privacy Act, allowing an employer to make further inquiry as to that where there is a question of health and safety of other employees. So the alleged malingerer may be displaying the sniffle in the view of the employer, but you've got a greater obligation to the rest of the staff that are at that workplace under the Health and Safety at Work Act to ensure their safety. And if there was more than just the sniffle and it turned out to be the dreaded lurgy, that employer could be in some significant trouble with health and safety issues for failing to keep a safe workplace. So it's not an easy question to answer, but you have to be mindful of the times that we're in. And there are exemptions available under the Privacy Act to seek and require further information.
Another question just come through. Thank you for submitting your questions. And this person asks, if businesses can commence normal work after the current 4-week period, and again, assuming that after 4 weeks we're going to go back and it's not extended, but have been paid a subsidy for their staff for 12 weeks, do they continue to pay out the subsidy over the full 12 weeks, topping up to a full wage, or would they have to pay back the balance to work and income?
My view on this is that you wouldn't have to repay the subsidy to work and income if the employees are still engaged and you are distributing the subsidy wages to them. It's very clear that the subsidy is for wages only. It is not for ordinary business expenditure, and that's another reason why we were suggesting that you'd be wise to place it into a separate bank account. Some businesses I know will operate a PAYE bank account. Something similar to that would be a good idea to segregate that money. You can often do it through your online banking app. It's very simple to open a new checking account or savings account in which to isolate that money. But be under no mistake that there is a reclawing ability for MSD to recover any money that you were not entitled to. And if an employee leaves, for instance, by handing in notice and leaving halfway through the subsidy period, then the residual undistributed subsidy relating to that employee is no longer an entitlement to the business. And so you must keep in mind that would need to be refunded.
Anything else to add on that one?
No, nothing to add there. I concur with James's view on that. It's been made clear that it's for wages. We've talked about the importance of businesses isolating that payment in a separate account, safe harbouring it, and we've talked about the look back powers of MSD in future. And I think if an employer keeps that money sequestered into a separate account, it's used solely to pay wages. Based on our understanding of the current advice around the subsidy, we've seen no suggestion that the government is going to recall the subsidy payment. So long as you play within the rules.
We have two final ones, and then we'll close this webinar out. Thank you for being with us. This one, lots of companies started up new hygiene precautions, and I imagine once we come back to work after this lockdown period, there are still going to be some fairly stringent hygiene and sanitisation procedures in place. If there are people in the workplace who are creating problems, aren't following these new procedures, or aren't getting on board, what options do you have as an employer?
My view, again, referencing the Health and Safety at Work Act, is that the duties under that Act flow both ways. So that means both employers and employees must adhere to the obligations to keep the workplace healthy and safe insofar as reasonably practical. Therefore, if you had an employee who was ignoring or flouting those rules, policies, and those sorts of things, you would potentially, in my view, have scope to exclude them from the workplace. But winding that back, obviously, before we all head back to work eventually, when that day dawns, it's the old story of information is key. Information is knowledge and power. So, disseminating to your employees what the new protocols, cleaning and otherwise may be, so that you first of all alert everyone in good faith to what the changed landscape may look like. And as always, with any policies or protocols that you're looking to implement in the workplace, is seeking consultation via feedback on those. So giving the ability, so being prepared, forewarned is forearmed, for staff, getting those policies out or protocols or changes out to staff, giving them a time period to consider and come back to you with their feedback or concerns around that. And there will be some concerns, there will be feedback. Sometimes there's nothing but deafening silence, but at least you've discharged your obligation as an employer in good faith to consult. And then if you've got comment and feedback and concerns, to consider that and to work through that with staff. But ultimately, as an employer, you have obligations under the Health and Safety at Work Act, and in my view, that entitles you to take appropriate measures in the workplace to keep your employees safe when they return to work. If you've got someone who is not wanting to comply with that, or saying that that's not right or whatever, I think you need to consult with that party to try and find out where they're coming from, to understand it. And ultimately, if you reach a loggerheads, the employer, in my view, has the right to make the call on what practices will be implemented. And if an employee is not going to go along with that, then that could be the failure to follow a lawful and reasonable instruction, and it could also see the employer having grounds to exclude them under the provisions of the Health and Safety at Work Act.
Just add a cautionary note in there. Brad is absolutely correct with the constructive and proactive approaches, but you, as an employer with an employee that's not following reasonable instruction, if you descend into disciplinary processes, it's very important to conduct those in a fair and reasonable and not an arbitrary manner, so that the employee has fair opportunity to respond and put their views. So don't launch off and tear them a new one without first exploring the suggestions that Brad has made.
Anything else, Andy?
I think also the underpinning starting point for that requirement is that the employee is aware of that policy, has been made aware of it, must be made aware of it. If it's some policy that's tucked away somewhere or just plucked out of the air by the employer when the employer sees fit, then there may be some difficulty in even justifying it as a lawful and reasonable instruction. So again,
I'm very quick to point out that I'm not a lawyer, but the final question we had for today was, do you need to have a beard in order to be part of the employment law team at Godfrey's Law?
Short answer, yes.
Yes, that's in the statute.
Goes with the territory.
Yeah. Old Mates Act 1952, subsection 1A.
BC.
Well, it's good to have a bit of humour and a bit of a laugh. Thank you so much for joining us for this webinar. If you have any further questions, if you've got a specific case that you'd like to put to the team, tell us how they can get in touch with you and how they can take it further.
Sure. Yeah. Thanks, Cameron. Yeah. Look, firstly, thank you everyone for joining us today in these unprecedented times, and appreciate that you taking the time out to listen to us today. We are still operating. It's business as usual, in a manner of speaking. We have been preparing for the last few weeks for this eventuality, and our preparations have stood us in good stead despite some technical difficulties earlier today, in that we're all up and running remotely, as many people will now be doing. You can get in contact with us in a variety of ways. You can head to our website, www.godfreyslaw.co.nz, and you can find out a bit more about the panellists today, as well as our other team members, as well as all our contact details. You can call our main line on 3667 469, and Brock, our receptionist, will take your message and forward it through to the team. And also you can contact us via email. It's pretty simple for all of us. It's either Andy or Brad or James at godfreys-law.co.nz, or lowercase. And many of you already have our contact details. We are continuing to take phone calls. We're up and running in that regard, and we've got multiple different channels for communication. So Zoom, FaceTime, Skype, all those sorts of things. Obviously, we won't be meeting face to face, but we'll be doing it virtually, and we're up and running during usual office hours and potentially outside of those for the likes of myself, for clients who have questions or need help. So we're still going, and we'll be here for the duration.
Perfect. Anything else to add, gentlemen?
I just wanted to make some general comments, if that's okay. I've had the benefit of reading the Beehive release paper, and I noticed an overarching theme coming through, which is that all of the financial support packages being offered they're being put in place for workers and businesses. It's a common theme that it's a trust relationship that's being established, that the support is for workers and businesses. I've heard some rumours around town that there are employers who are applying for these subsidies, receiving subsidies, and then letting their employees go, and otherwise using this money to keep their businesses alive. And I think it probably goes without saying that that is certainly not what was intended for the use of these subsidies. So everybody, please keep that in mind, that they're for the support of workers and businesses.
Cool, thanks, James.
And sorry, just Cameron, one final message from me. I mean, I think we've heard this and we've said it before, and we've all displayed it in Canterbury and in New Zealand. It's a case of kia kaha. We are all in this together. We are one nation, and we are all facing the same threat, whether you be an employer or an employee. And these are damn scary times, and I'm not afraid to admit that myself as a business owner. But we're not alone, and I think the government has shown some real leadership to date on this by the packages they've announced so far, and no doubt the packages that will come through in the coming days and potentially weeks. And I think it just reiterate my opening message, and there were some technical difficulties at that time, so it may not have been clear that we all need to breathe, and this is an evolving and fluid situation, and I think it's too early to make any knee-jerk reactions at this point in time, whilst keeping an eye on our obligations and everything that we need to. But I think it's a case at the moment for me as a business owner and as an employment lawyer of sitting tight and tiding ho just for a little bit longer, because I think we're going to see some significant announcements in the coming days before the end of the week. So there are some very real steps we can take right here, right now. Andy has reiterated a key message for me of getting in contact with your bank manager, with your bank, having those conversations with your bank as soon as you can. And I know people that are already doing that as to what sort of relief they can provide, and watch the space, I think. But be proactive, don't sit back, be proactive and get on the phone to your bank manager. I know we have, we've been in discussion with our bank manager, and I think bank managers see that as a sign of strength, not weakness, that you're keeping your eyes peeled and you're alive to the risk and you're acting prudently. And I think there's nothing worse than non-communication with your bank manager or the IRD, for example. In terms of some businesses will have terminal tax payments that are coming up in the near future, 8 April off the top of my head, and getting in contact with your accountant and seeing what can be done there in terms of, potentially looking to delay those payments. And the key is obviously getting in contact with IRD and opening those conversations. So there are a variety of different things that you can look to do. So I really think there's a smorgasbord of options available, and that we're all in this together, and we will get through. I think the government's been very prudent in the steps it's taken. We want to limit the fallout and exposure, and this is all part of it. And I think we all need to bear that in mind, that at the end of the day, we've all got to live, we've all got to eat, we've all got to pay the bills. And I think if we all pull together, we can pull through this. There will be occasions where some hard decisions are going to need to be made, and I'm not ignoring that for a moment. But I just think tide ho, kia kaha, and we're in this together, and we can pull through. And there's a variety of things coming, I think, that are going to help everyone get through this time. So just stay safe, stay healthy. We're thinking of you all, and we're here for you if you need us in any way, shape or form. Wherever we can help, we will endeavour to do so. And we've got a great team. So thank you today to Cameron for moderating this and for working through the technical difficulties, and for all of you for persevering. We do appreciate it. And thank you, James and Andy, for your expert and considered input today.
Brilliant. Thank you so much, gentlemen. Just to reaffirm that the team at Godfrey's Law are working remotely. They are contactable, and we will endeavour to make this webinar available on the Godfrey's Law website, godfreyslaw.co.nz. And if you've got any specific questions or queries, you'll find all the contact details there and address them to the team. Kia kaha, thank you so much for joining us, and we'll be in touch again soon. Cheers.
Thank you.